The patient had only a slight cataract, and the doctor reassured her that if she had the cataract surgery, everything would be fine. Well, it wasn't fine. She went in for cataract surgery, came out blind. Does she have a case? You want to learn the answer? Come join me as I share with you this great information. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury trial lawyer practicing law here in the state of New York. The answer is maybe. We have to look and evaluate to see what were the indications for this patient having cataract surgery. Was she a candidate for this particular surgery? And then we have to look to see whether the doctor violated the basic standards of medical care. Were his calculations correct? And if they were, did he do the procedure correctly? Now, there are always inherent risks with any type of surgical procedure, and one of the risks involved damage or injury to the organ or to an adjacent organ. And I guarantee you that now, if you go back and look at the paperwork the patient signed, it's going to say there is a risk of injury following this procedure, and you can go blind. The mere fact that the patient now can't see after the procedure, does that automatically mean the doctor violated the basic standards of medical care? The answer is no, not automatically. We now have to look and evaluate to see what it was that the doctor did. Was this patient a candidate for the procedure? Was the procedure done correctly? Were there any complications that arose? What caused the patient's blindness? Did the doctor inadvertently cut the patient's optic nerve? Was something else going on that now we have to determine whether or not it was appropriate medical care and treatment? So to answer the question, just because you go into a procedure otherwise healthy, and now you come out with a significant injury like being blind, does not automatically mean that you have a valid case. It might, but we have to confirm that with a medical expert who has reviewed all of your medical records. So why do I share this great information with you? I share it with you because so many people pick up the phone and call and say, listen, I went into the hospital healthy, now I came out in a wheelchair, I think the doctor or hospital staff did something wrong. Can you help? And that's when we begin to ask questions and look into what type of treatment you had to evaluate and determine whether or not we are able to show that there was wrongdoing, that the wrongdoing caused injury, and that the injury is significant and or permanent. And by the way, we have to do that by showing that we're more likely right than wrong. So why do I share this great information with you? I share it with you just to give you an insight and an understanding to what goes on in claims involving medical negligence and medical malpractice here in the state of New York. You know, I realize you're watching this because you're contemplating bringing a lawsuit for care and treatment you received by a doctor who you believe was careless. Well, if your matter happened here in New York and you do have legal questions, what I encourage you to do is pick up the phone and call me. I can answer your legal questions. You know, this is something I do every single day, and I'd love to chat with you. You can reach me at 516-487-8207 or by email at Gerry, G-E-R-R-Y, @oginski-law.com. That's it for today's quick video. I'm Gerry Oginski. Have a wonderful day.